so much for coming, everyone. I'll give you a minute or so to take your seats before we go ahead and get started. My name is Veronica Maska, and I'm the president of Use Vitae. On behalf of the club, we would like to welcome you all to this debate today. The debate is on the fetal personhood and the 14th Amendment, and in particular, the original public meaning. So the question is whether the Constitution, as it currently stands, protects the right to life for the unborn. Now, this is a really important question I think should be central to anyone who cares about protecting every single member of the human family in life. The question is if we already have provisions in place in the Constitution, or if we need to work to perhaps make additional provisions to protect life. So joining us today are two wonderful, committed pro-life debaters, speakers, and attorneys. Their pro-life credentials are impeccable, and this is a really important point that reasonable pro-life people can disagree on this question. It's not a question of if you are pro-life or not, but if you approach the Constitution from a religious perspective, it's a question of history. It's a question of scholarship and the original public meaning. Use Vitae is the pro-life club here at the law school. If any of you are interested in getting more involved with the club, we have a GroupMe link up here that you can scan with the QR code. And we put on events like this to highlight the academic debates in the pro-life movement, as well as service projects where we witness the beauty and dignity of every single human life. I'd like to take a moment to thank our co-sponsors today. First, we have the Notre Dame Center for Citizenship and Constitutional Government, and also the Notre Dame FedSoc. And a quick note about logistics, we will be serving lunch at this event. Don't second guess your decision to come right away. We're not allowed to serve in the courtroom, so immediately after the debate, we'll have Chick-fil-A out in the lobby. And with that, I'll introduce our moderator. Our moderator today is Tyler Castle. He is the Associate Director for the Center for Citizenship and Constitutional Government and a PhD candidate in political science here at Notre Dame. Previously, he spent nearly a decade working at the American Enterprise Institute in Washington, D.C., directing its initiative on faith and public life. We are honored to have Mr. Castle as our moderator today, and as a former Tocqueville Fellow, it is a delight to partner with the Center for Citizenship and Constitutional Government. And with that, I'll make a quick note about Q&A. We will have audience Q&A for our panel. So I'll go to that slide. This is the QR code for Q&A. During the debate, feel free to scan the code and enter your questions, and we'll send those to our moderator after our panelists have a chance to give initial presentations and ask each other questions. And with that, I'll pass it off to Michael to give a brief announcement from our other co-sponsor before he brings you back to the regularly scheduled programming and introduces our first speaker. Thank you.
Thank you, Veronica, and thank you for the turnout today. We're so pleased. And like I said already, or rather as Veronica mentioned, this is being co-sponsored by the Notre Dame Federalist Society, and just wanted to flag that for all of you so that you're cognizant that there will be an email soon with an announcement about a new initiative to help 1Ls heading into the exam season. And with that, I'll go straight into introducing one of our guests here today. So Joshua Craddock, seated right here, is an affiliated scholar with the James Wilson Institute. And as a practicing lawyer, he has successfully petitioned the United States Supreme Court for certiorari and prevailed in Vega v. Tekoa. He's also a graduate of the Harvard Law School, where he served as editor-in-chief of the Harvard Journal of Law and Public Policy. He clerked for the Honorable Chief Judge Timothy Timkovich on the United States Court of Appeals for the 10th Circuit. And prior to law school, Mr. Craddock managed advocacy teams for several nonprofit organizations at the United Nations. His writing has appeared in the Notre Dame Law Review, the Harvard Journal on Legislation, the Washington Post, Newsweek, and National Review. And I will turn it over now to Grace Kalla, who will introduce Mr. Forsythe.
Good afternoon, everyone. Thank you for being here. My name is Grace Kalla, and I am a 2L here in the law school. I have the honor of introducing Mr. Clarke Forsythe here with us today. He's currently the senior counsel at Americans for Life and has an extensive history with the organization dating back to 1985. Since then, he has served 6 years as vice president and general counsel, overseeing nationwide litigation and legislation strategy, and 10 years as president. He's the author of several books, including Pushing Roe v. Wade Over the Brink, The Battle for America's Heart, The Human Right to Life, and A Future Full of Hope. Mr. Forsythe has published over 19 law review articles, including one in our very own Journal of Law, Ethics, and Public Policy entitled Roe v. Wade and the Legal Implications of state constitutional personhood amendments. He has a bachelor's in political science from Allegheny College, a master's in bioethics from Trinity International University, and a law degree from Valparaiso University School of Law. We are honored to have our three guests with us today.
Okay, we're going to get right to it. Thanks to Veronica and the team. Again, I'm Tyler Castle with the Center for Citizenship and Constitutional Government here at Notre Dame. And just to say a few words about the format for today's debate. First, we'll have Josh give his affirmative opening statement, arguing that the unborn are covered by the 14th Amendment. He'll have 20 minutes to give his opening statement. Then we'll turn to Clarke, who will give a 20-minute opening statement as well. And then they'll have a chance to ask each other questions for 15 minutes, and we'll throw in some audience questions as well. So again, as the debate is going on, please scan the QR code and enter your questions, and we'll ask those at the very end. So without further ado, Josh.
Thanks very much to all of our sponsors, especially Vitae. And thanks again to Clarke for agreeing to do this debate. Even though we disagree on this legal issue, we agree on so much and are in the same fight together. So thank you for joining me today on this important topic. Now, a century and a half ago, we fought a civil war and we amended the Constitution to ensure that every human being could enjoy the equal protection of the laws. But today, some states have denied that protection to children in the womb through legalized abortion. Now, from the moment of fertilization, these unborn human beings are fully human. And in our legal tradition, every living human being is a legal person. The Constitution says that no state can deprive any person of the equal protection of the laws. And that's why I stand resolved that the conservative legal movement should pursue a 14th Amendment strategy to ensure recognition of unborn children as constitutional persons entitled to due process and the equal protection of the laws. Like overturning Roe, this is likely to be a long-term effort, but our existing Constitution is up to the task. Regrettably, some critics disagree not only with the prudence of such an approach, but also with its soundness. They believe that unborn children are the only class of human beings whose natural and legal rights the Constitution fails to equally protect. Though this position is often framed as the sober-minded perspective, I think that denying personhood at this critical juncture in our constitutional history would be neither legally sound nor politically prudent. So to understand why constitutional personhood is the next logical step after Dobbs, we must carefully attend to the Supreme Court's decision in Dobbs. As we'll see, that decision is consistent with and even favorable to a future ruling securing equal protection to unborn children. Nothing in Dobbs forecloses a ruling recognizing unborn personhood. Neither does anything in the decision prohibit states or the co-equal federal branches from recognizing the same. Then we'll revisit the historical evidence showing that unborn children are persons within the meaning of the 14th Amendment. And then finally, we'll consider the practical and political implications of acknowledging that obvious truth. So first, what did Dobbs actually say? Well, to properly interpret Dobbs, we have to distinguish the holding of the decision from the dicta in the decision, right? So the holding is the legal rule that actually resolves the case, while the dicta is its tangents, its asides, and its commentary that's not strictly necessary to deciding the question presented. And the only issue squarely before the court in Dobbs was whether the Constitution prohibits states from regulating pre-viability abortions. And the court's answer was simple: no, because the Constitution does not confer a right to abortion. The court didn't need to decide whether unborn children are constitutional persons to answer that question, and neither party to the case raised that issue. So it'd be extraordinary then if the court had nevertheless decided it. As Chief Justice Roberts noted in his separate opinion, courts follow a fundamental principle of judicial restraint by declining to formulate a rule of constitutional law broader than is required to the precise facts to which it is applied. By reserving any decision on personhood for the future, of course, the court necessarily, quote, returned the issue of abortion to the people's elected representatives. But that practical implication of the court's ruling should not be confused with the statement of legal principle. It does not mean that the majority adopted Justice Kavanaugh's position that the Constitution is neutral about abortion. Indeed, the majority emphasized that its opinion is not based on any view about if and when prenatal life is entitled to any of the rights enjoyed after birth, including Justice Kavanaugh's view. So despite some overbroad dicta, the logic of Dobbs actually militates toward recognition of the unborn child's constitutional personhood. No fewer than 5 times in the majority decision, the majority observed that, quote, abortion is critically different from any other right this court has held to fall within the 14th Amendment's protection of liberty, because it destroys what Roe and Casey called fetal life and what the law now before us calls an unborn human being. The majority repeatedly stressed this point as, quote, the critical moral question posed by abortion. Indeed, the court even cited historical evidence that, quote, an infant in ventre sa mère is regarded as a person in being, in the womb in French. At the heart of Dobbs, then, is the unavoidable fact that abortion takes a human life. And if abortion takes a human life, then the question necessarily arises whether that living human being is, like every other human being, a natural and constitutional person, entitled to the same or equal protections as born persons. So far from precluding prenatal personhood, Dobbs actually takes strides toward its future recognition. The Supreme Court now has no holding concerning an unborn child's constitutional personhood, and it would be entirely consistent with Dobbs for a future court to hold that unborn children are, or through constitutional legislation or through a presidential executive order, that unborn children are constitutional persons within the meaning of the Equal Protection Clause. So second, let's move to the historical evidence of what Section 1 actually meant. So it's now well established that when the 14th Amendment was ratified in 1868, the word person had a settled public meaning that included every human being, including children in the womb. Now, why do we have to look at that settled public meaning? Well, it's because the Constitution in Section 1, the 14th Amendment, doesn't define the term person. Now, a lot of people stop me right there when I'm making this argument. They say, Josh, how could you be making the argument that unborn children are persons within the meaning of Section 1 when it says born right in the third word? Right? It says all persons born or naturalized and subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. So it says born right there. How could you say persons include the unborn? Well, if you read carefully, it's defining citizenship. It's not defining persons. So we're taking this broad and undefined class of persons, all persons, and then we're adding constraints. They have to be born or naturalized and subject to the jurisdiction of the United States to be citizens of the United States. So we're taking a broad and undefined class of persons and narrowing it down to define citizenship. So that's the citizenship clause. That's the first sentence, right, in Section 1. Then we go to the privileges or immunities of citizenship in the next clause, right? It tells us what privileges and immunities citizens of the United States have. But then you'll notice that the subject shifts. After the privileges or immunities clause, when we move into the due process clause and the equal protection clauses, we're no longer talking about citizens, but any person, returning again to that broad and undefined class. And so that's why we have to look to indicators of original meaning. And those historical indicators, you could look to several things. You could look to things like, for example, dictionary definitions, legal treatises from the time that the text was adopted. You could look to common law precedent and statutory history to help inform the meaning of that term. And finally, you could look at what the amendment drafters and ratifiers themselves said as an indicator of that original public meaning. So let's look at some of those lines of evidence. Let's start with the definitions. According to dictionaries of common and legal usage, at the time of the 14th Amendment's adoption, the term person was largely interchangeable with human being or man in the inclusive sense, as in mankind. The 1864 edition of Noah Webster's American Dictionary of the English Language defined the term person as, quote, relating especially to a living human being, a man, woman, or child, an individual of the human race. In legal usage, every human being was considered a natural person, right? So you had artificial persons like corporations, right? And then you have natural persons. The class, every human being would be a natural person. The authoritative treatise writer William Blackstone actually began, every founder of the United States would have had, if they had If they had books on their shelf, there would have been the Bible, Shakespeare, and if they were a lawyer, they would have had a copy of Blackstone's commentaries, right? And if you can believe it, he begins the commentaries, he begins it with a book on the rights of persons. And he actually begins that book with a discussion of the unborn child's right to life and personal security. So Blackstone says that life is a right inherent by nature in every individual, and it begins in contemplation of law as soon as an infant is able to stir in its mother's womb. Now, this mention of the unborn child stirring is designed to protect life as soon as it can be detected, not to exclude protection prior to that point. So it's proper to derive the principle from Blackstone and these other treatise writers that as soon as life could be shown to exist, legal personhood existed also. There was no distinction for Blackstone and these treatise writers between biological human life and legal personhood. The 14th Amendment, similar to the Civil Rights Act of 1866 that it was meant to support, codified equal protection of these fundamental rights of persons as those had been expounded by Blackstone and other treatise writers. But second, let's look at state practice. Centuries of common law practice consistently treated the preborn child as a person whenever it would be to his benefit. So based on authorities like Lord Coke and Blackstone, as well as landmark English cases, state high courts in the years leading up to 1868 declared that the preborn human being throughout pregnancy, quote, is a person, and hence under civil and common law to all intents and purposes, a child as much as if born. And that's from Chief Justice Shaw of the Massachusetts Supreme Judicial Court way back in 1834. Now, one decision cited favorably in Dobbs actually uses language that bears a striking resemblance to the 14th Amendment to make the point, saying that a child in the womb of the mother is under the protection of law and possesses all the privileges of a living human being. Now, as Dobbs shows, the unborn child was considered a legal person across many bodies of law whenever it would be to his benefit. And at common law, abortion was unlawful at all stages of pregnancy, and it was typically criminally indictable as soon as a woman was quick with child, a phrase that had shifting meanings. We've already touched on this a little bit, but some courts understood this to be as soon as the child was alive, while other courts said that it was soon as the child's movement could be detected or quickening. So there was some linguistic shift or drift between different courts and how they applied this concept. But the principle of the rule, again, was to protect life as soon as it could be shown to exist. Because even though every living embryo was a quick child, some courts used that quickening distinction, right, the first perceived fetal movement, as a useful evidentiary tool for determining whether the crime of abortion had taken place. Because there was great difficulty in proving that the child was alive prior to quickening, and of course, killing the child was an essential element to the crime of abortion. In any event, the quickening distinction was largely discarded as in the statutory reforms that happened as in the lead up to the amendment's adoption in 1868. So that by 1866, Chief Justice Tenney of the Maine Supreme Court could accurately report, quote, that the quickening distinction has been abandoned by jurists in all countries where an enlightened jurisprudence exists in practice. Now, when the 14th Amendment was adopted in 1868, the states widely recognized preborn children as persons throughout pregnancy, and nearly every state had actually codified criminal prohibitions against abortion by statute, in addition to that common law, right? Because there's a trend toward codification of criminal law, right? So we're moving away from common law crimes towards statutory codification. And by the time the amendment was adopted, 28 jurisdictions labeled abortion as an offense against the person within their statutory code classifications, or a functional equivalent, right? In your code, you might have offenses against property, you might have trespassing, for example, or you might have offenses against the person. And that's where the crime of abortion was located in these statutory codifications. In 23 states and 6 territories, laws referred to the preborn individual as a child. And in fact, the same Ohio legislature that ratified the 14th Amendment called abortion just 3 months later, at any stage, nothing less than child murder. Strong words coming from the 1800s. So at the time of the 14th Amendment's adoption, nearly every state understood person to include prenatal life. Finally, the framers' understanding of the amendment's legal application. What did they expect it to accomplish? The primary framer of the amendment, Representative John Bingham, believed that the amendment prevented states from refusing, quote, any of the rights that pertain to common humanity. Senator Jacob Howard, who sponsored the amendment in the Senate, declared that the amendment's purpose was to disable a state not from depriving not merely a citizen of the United States, but any person, whoever he may be, of life, liberty, or property without due process, and that even the lowest and most despised of the human race would be guaranteed equal protection. As Justice Hugo Black later put it, the history of the 14th Amendment proves that people were told that its purpose was to protect weak and helpless human beings. Now, one mistaken originalist argument might claim that the preborn can't be protected by the 14th Amendment because it begins with that language about born or naturalized, right? And we already discussed that. But another mistaken approach to constitutional interpretation might claim that the 14th Amendment doesn't protect preborn children because it was most immediately intended to protect Black Americans against unequal discriminatory treatment. But the amendment's framers deliberately chose that broader term person to protect any human being who might be denied due process or equal protection. But some still wonder, if the 14th Amendment equally protects the unborn from homicide, why didn't the framers say so expressly in the ratification debates? Or why didn't every single state immediately enact new statutory laws? Well, first, remember that the common law already prohibited all abortion, even if it wasn't always criminally indictable earlier in pregnancy. And even early in pregnancy, abortion functioned as an inchoate felony for the felony murder rule purposes. Second, congressional silence is completely unsurprising in this context. As we've just seen, when the amendment was adopted, the states widely prohibited abortion and recognized the unborn as persons. Unlike Black Americans, the law already protected the unborn. So it's utterly unsurprising the legislative silence about the amendment's application to the unborn specifically, because state laws denying equal protection were not enacted until nearly a century later. Finally, this argument from silence rests on the questionable premise that Congress meant only to achieve specific and immediate ends rather than create generally applicable rules of decision. Originalist lawyers and judges today understand that what a text requires may be different from what originally what the lawmaker might have foreseen. As Justice Barrett recently explained in Rahimi, originalists have to distinguish between, quote, original meaning, which controls, and specific expectations about how the text would apply, which do not. Early applications of a constitutional rule can help illuminate its original scope, but an interpreter must exercise care in considering them. So consider that when the 14th Amendment was adopted and for long after, bastards were not equally protected under the laws of most states. For example, Louisiana deemed the statutory term child to mean only a legitimate child. The amendment's framers never discussed illegitimacy, and it wasn't until 1968 that Levy versus Louisiana applied the Equal Protection Clause to illegitimate children, explaining that they are, quote, not non-persons because they are humans, live, and have their being. Now, it would be odd to interpret congressional silence about illegitimate children as evidence that such children were meant to be excluded from the amendment's protective ambit. We conclude that the Supreme Court got the original public meaning of person wrong in Levy. Arguments from silence are often weak, and I think this is no exception. So finally, politics and prudence. What are the implications? Now, some might say, even if everything you've said is true, this isn't the most politically prudent strategy. They point instead to a human life amendment, for example, requiring 3/4 of the states and a 2/3 vote of Congress. But I believe that that alternative may be no alternative at all, in the sense that a nation that could muster the supermajorities to accomplish it would hardly need it. Now, detractors make much of the view that no Supreme Court justice has ever adopted the personhood view, and they argue that this strategy would be imprudent for that reason. But numerous justices acknowledge that if an unborn child is a person, abortion would then necessarily be outlawed nationwide. In fact, Justice Blackmun famously conceded as much in Roe. More importantly, the meaning of the 14th Amendment is not determined by the agreement of the justices. It certainly wouldn't be the first time that a constitutional application has slept unnoticed by its robed interpreters. For example, before DC versus Feller, no justice over the course of 2 centuries had ever expressly stated that the Second Amendment protected an individual right to bear arms, yet an originalist court held so in 2008. But again, the courts were never intended to be the primary enforcers of the 14th Amendment. So what would a pro-life 14th Amendment strategy look like? Well, rather than fixating solely on the judiciary, a long-term pro-life 14th Amendment strategy would also focus on state as well as congressional and executive action. The most natural and immediate avenue for advancing equal protection is through Congress. Section 5 confers on Congress an enumerated power to, quote, enforce by appropriate legislation the guarantees in Section 1. Dobbs didn't determine how a future Supreme Court might view national pro-life legislation enacted under Section 5, and even Justice Kavanaugh acknowledged twice that future abortion policy may be addressed, quote, in the states or Congress. Now, every Republican Party platform between 1984 and until this year supported, quote, legislation to make clear that the 14th Amendment's protections apply to children before birth. But if the unborn are not persons within the original meaning of Section 1, then Congress would lack power to enact national life protective legislation, such as the Life at Conception Act, Heartbeat Bill, or 15-week law. The next pro-life president also has a role to play. In a 1988 proclamation, Reagan called for the personhood of the unborn to be declared and defended throughout the land under the 14th Amendment. So the next pro-life president can fulfill his Article 2 duty to, quote, take care that the laws be faithfully executed by issuing an executive order to ensure that unborn children are treated as persons by each department and agency under the executive branch authority. But if the unborn are not persons within the original meaning, then I think the president may lack authority to issue such an order. Now, in the years following Roe, there was a lot of discussion and dissension about the path to take, and the same will be true of the pro-life conservative movement as it navigates its success in Dobbs. But it would be unfortunate if at this early hour, advocates for the unborn discarded the use of one of their most powerful legal tools. If the unborn are human beings, as they undeniably are, then we must have the courage of our convictions to seek their full acknowledgement of persons under the Constitution. And we would do well to remember one of Justice Robert Jackson's greatest opinions, in which he said, quote, one's right to life may not be submitted to a vote. It depends on the outcome of no elections. The foundational error of Roe was not that it short-circuited the democratic process, but that it denied constitutional personhood to the weakest and most vulnerable among us. Thank you.
Thank you, Josh. We'll now hear from Clarke.
Well, I would say this is getting fun. Josh and I think this is the fourth time that Josh and I have debated this in a number of different forums. And after 3 or 4 times, I think I'm getting to understand that what we're really debating is what does the original public meaning mean? And we'll get into that, and hopefully there'll be time for questions about that. But first, I want to thank Veronica and Michael and Grace for organizing this, and for the co-sponsors' support as well, especially the Federalist Society and the Center. And I want to thank Josh for re-engaging this again. I really think we should take it on the road to other forums, because I think it's an important question, not just about the 14th Amendment, but about original public meaning, and whether the 14th Amendment is really the best vehicle for protecting the unborn. Now, how many of you have read all of Roe versus Wade and all of Dobbs versus Jackson Women's Health Center? Okay, well, good. I hope I can cast some more light on Dobbs. Anyone who's read my 1987 Valparaiso University Law Review article on the Born Alive rule knows that I affirm the moral personhood and the statutory personhood of the unborn child. But just because it is a person in one context doesn't mean it slips into the word person everywhere in the federal code or everywhere in the Constitution. There has to be a decision, an intent by the framers of those laws to so include the unborn child. And I think that what Josh's presentation raises is a number of different questions besides what is the original public meaning. Why would the 39th Congress take the issue away from the states when the states were the center of anti-abortion activity from 1820 to the 1870s and beyond. The states were the locus. The states were the forum. The states were the center for state by state, year by year protection of the unborn child. But just like Roe took the issue of abortion away from the states and centered it in the justices, declaring that the unborn child is a person would also take it away from the states. And everything that Josh said about treatises, dictionaries, state practice are all related to what the states were doing and the common law. But they have no connection whatsoever to what the 39th Congress was doing. What the expansive statements that Bingham and Howard were saying were in the context of racial inclusion, racial equality. They had nothing to do with biological equality. You can't see any part of the legislative history of the 14th Amendment, any statement, committee report, anything in the states, any op-eds of the time, nothing mentioned the unborn or pregnancy or abortion. And there's an excellent reason for that. It was focused on the states. And one of the great achievements of Dobbs is that it restored to our understanding, if you look at the appendices and the majority opinion, it basically restored our legal and cultural heritage. For 50 years, the US Supreme Court stole our legal and cultural heritage and of Anglo-American law and Anglo-American medicine. And Dobbs restored our legal and cultural heritage. And that, unfortunately, has been ignored too much. Dobbs was necessary because Roe was so bad. And to understand how important Dobbs was in the face of the conservative disparagers of Dobbs, you have to understand how bad Roe was. And I encourage you to read Abuse of Discretion, the Inside Story of Roe versus Wade, my book on the deliberations in the 2 years leading up to Roe versus Wade that explain how bad Roe was. There was no evidentiary record in Roe. There was no factual record in Roe. The court, everything in the majority opinion in Roe is based on Justice Blackmun's own research or those of his clerks or of interest group briefs filed in the Supreme Court for the first time. No evidentiary record in Roe or Doe whatsoever. So Justice Blackmun, after a court of just 7 justices, because Harlan and Black had retired before the first oral arguments, there were just 7 justices. 4 decided they want to sweep away the abortion laws before those vacancies could be filled. And they decided to take Roe versus Wade and Doe versus Bolton, even though those 2 cases weren't taken by the court in April of '71 to decide the abortion issue. They were taken to decide the application of Younger versus Harris, which you'll recognize as a jurisdiction case. Roe and Doe presented those scenarios. But after Harlan and Black retired in September of '71, it reduced the number of justices to 7, and 4 pro-abortion justices decided they were going to use these 2 cases to declare a right to abortion and sweep away the abortion laws before the vacancies could be filled. So Dobbs restored our legal and cultural heritage, and it erased the false history of Roe versus Wade. It expressly overruled Planned Parenthood versus Casey and Roe in several passages. It effectively erased the amorphous right of privacy in Roe, and that means states have clear constitutional authority to protect human life. The court declared that no implied or unenumerated right to abortion was lurking elsewhere in the Constitution. And Dobbs strengthened federalism and the state's police power, which again means that the states have clear constitutional authority to protect life from conception to natural death. And Dobbs affirmed that the states have a rational basis to protect the unborn child and a rational basis to protect the unborn child or prenatal human beings at all stages of development. The result, which has been overlooked, is that whereas Roe was a great deal of confusion, Dobbs was crystal clear. State officials announced within hours their intent to enforce their abortion limits. State and federal courts enforced and obeyed and applied Dobbs, and 35 or more federal court cases challenging marginal abortion regulations were dismissed. And we now have gestational limits at 12 weeks or less in 18 or 20 states. But if you read Dobbs, it's clear to me at least that the court settled the issue of 14th Amendment personhood for the foreseeable future. It was raised at oral argument. It was briefed by amicus, and it was effectively rejected unanimously, as it has been since 1971, the court's first modern abortion decision, United States versus Village. Listen to these 6 passages from Dobbs. Quote, for the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens, unquote. In other words, the 14th Amendment did not change state authority on abortion. Quote, it's time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most questions in our democracy, by citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand. What could be stronger or clearer? Quote, the people of the various states may evaluate these interests differently. In some states, voters may believe that the abortion right should be even more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that the abortion destroys an unborn human being, unquote. Quote, our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Quote, the court in Roe usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Unequivocally leaves for the people. What could be clearer or stronger? And finally, quote, Roe and Casey must be overruled and the authority to regulate abortion must be returned to the people and their elected representatives. Is it plausible that Alito, Barrett, Gorsuch, Kavanaugh, and Thomas are going to say, oh, we made a mistake. In Roe, we took the issue away from the people. In Dobbs, we gave it back to the people, but no, we're going to take it back and control it. Now, I think Dobbs settles the question, at least for the foreseeable future. No one can predict the future entirely, but at least for the foreseeable future. But beyond that, there are good reasons, good legal reasons, beyond what they said in Dobbs for why the court won't touch it. And frankly, I would raise the question of when Congress, the 39th Congress, had passed the 13th Amendment in January of 1865, the 13th Amendment addresses a private action, slavery, and outright prohibits it. Why wouldn't Congress, if it was concerned about the abortion issue and really wanted to settle the abortion issue, why not follow the language of the 13th Amendment as a model prohibiting a private act? Why use all of the language of the 14th Amendment? One of the things that has struck me over the last 40 years about this debate is that the proponents only focus on one word, person. They don't, but the 14th Amendment is 80 words. After the first section, the first sentence of section 1, which talks about citizens, it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process or law, nor deny to any person within its jurisdiction the equal protection of the laws. 14th Amendment is about the states and limiting the states. It doesn't address private behavior. States don't do abortions. individuals do, persons do. Why didn't the 39th Congress follow the model of the 13th Amendment? It's simply not true that the settled public meaning at the time meant that persons included every human being, or that person included the unborn. Josh mentions dictionaries and legal treatises and state practices. How about the law? In the 1850s and 60s, the born alive rule, the common law born alive rule, was the law. It was the law according to Koch. It was the law according to Blackstone, which the court in Dobbs cited as common law authorities. And if you read my Valparaiso piece, you'll see all the history and all the medical context for the born alive rule. And I wrote the piece in 1987 to make the case that the born alive rule, which was founded in a period of primitive medicine, had become obsolete, and that legislatures should overrule it, repeal it, and courts should ignore it in the context of legal cases. But the born alive rule was the rule. It was the law in the 1850s and 60s. And although I believe it was an evidentiary rule, it was treated as a substantive rule of law by many authorities, even up until the 1980s. And by a substantive rule of law, they said that the prenatal entity is not a human being until it's born. Now, that was, I won't go into the details, you can read the Valparaiso article, but that was formed in a time of primitive medical understanding in 1600. In fact, the born alive rule goes back to the 1300s. But because of primitive medicine, because of the inability to understand prenatal development, there was a limitation on homicide law. The born alive rule was a limit on the homicide. You couldn't have a homicide of the unborn child unless it was born alive, and you could decide based on the evidence how it had been killed from natural or criminal causes. But the born alive rule was the law, and a future Supreme Court could easily look at the born alive rule and say that there wasn't a settled public meaning at the time. There were cases even after the 14th Amendment was ratified, even into the 20th century, that treated the born alive rule as a substantive rule of law, that the unborn child is not that the unborn entity is not a human being until it's born alive. And how many minutes do I have, Tyler? I think that language from those passages from Dobbs settles the question as long as this court remains. But there are those questions of text and context. The other thing, if you read the text and not just one word, but the whole text, is that the language of the 14th Amendment was specifically drafted to look at what the three branches of the southern states, executive branch, legislative branch, judicial branch, were doing to deprive the freedmen of civil rights. The 14th Amendment targeted the black codes, and the black codes in the South were involved taking away privileges and immunities, depriving the freedmen of due process, and denying equal protection. That's what the three branches of the southern states were doing. And it was written to target that. The problem with abortion is not privileges or immunities or due process or equal protection. And it's not equal protection, it's equal protection of the laws. The problem with abortion is one law, homicide, not killing the unborn child. What other legal rights or civil rights does the unborn child need before birth? Not to be killed. The 13th Amendment, that model can do that better than the 14th Amendment. So the text is important, and the legislative history is clear that the 39th Congress never considered the unborn child. But consider also this. There are real political and legal weaknesses to applying equal protection to the unborn. Constitutional equal protection. The states can do it. We have prenatal injury laws, we have wrongful death laws, we have fetal homicide laws, all enacted by the states, that's still working today. You're sitting in a state with a fetal homicide law that extends protection from conception, plus a wrongful death law that applies to the unborn, plus prenatal injury laws that apply to the unborn. But if you read the unborn child into the 14th Amendment, it's not limited to abortion. It would also apply to IVF and alcohol use during pregnancy and drug use during pregnancy. And if a woman had multiple babies, let's say a woman wanted a home birth, but then she finds out she's pregnant with twins or triplets, and she still wants a home birth. She doesn't want to go to a hospital. She wants the care of a midwife, not a doctor. At what point do the risks get high such that she has to be transported to a hospital for medical care by doctors, plus all of the technology we have? When does a home birth violate the equal protection of the laws? And when does the state have to step in to ensure equal protection? In the case of IVF or alcohol use or drug use or multiple fetal pregnancies. It applies to all those situations. It threatens state regulation of every delivery and labor because the states have to ensure equal protection. They have to provide equal protection. And it's any baby, it's any prenatal human being, not just in the case of abortion. And again, all these show that the 14th Amendment is not an effective tool. It's not well written to address the abortion issue. It was never intended to address the abortion issue. And if the Cause for Life wants a constitutional amendment, it's going to have to work through the states, through majority rule to garner 38 states. And if and when those 38 states are secured, in 25 or 30 years or however long it might be, it would be time to look at a carefully drawn amendment, not the 14th. Thank you very much.
Okay, now we'll have a brief time for the speakers to ask each other questions, and we'll give Clarke the opportunity to ask the first question of Josh.
I didn't give this much thought. But what the case look like and who would bring it and when to secure 14th Amendment personhood?
Sure. Well, again, I think you're focusing exclusively on the courts when, as I've said, this is a constitutional project that all three of the federal branches have a role in. But to the extent that the courts would be weighing in on this, there's plenty of ways that it could come up. One, for example, would be the Biden administration's VA hospital mandate requiring actual state actors in the VA to perform abortions, right? Under the APA, when you challenge under the APA, you can challenge as a regulation or a rule as something that's unlawful, right? It's contrary to law. One of the arguments under the contrary to law prong could be that it violates the Equal Protection Clause because it denies the equal protection of generally applicable homicide laws to the unborn in that context. So that's one example. Another example that came up recently was, you might guys remember the Garza versus Hargan case, right? There was a case during the Trump administration. There was a juvenile undocumented immigrant in custody who was pregnant, sought an abortion. She had to get a judicial bypass from a Texas judge. What about the state action of getting involved to grant a judicial bypass? And then when the court was reviewing it in the DC Circuit under whether these actions were lawful, why wouldn't they be able to consider that the Equal Protection Clause in that context? So I think there's lots of ways that this could come up, whether it's a private right of action or a administrative law situation. But I think there's lots of ways that this could come up.
This is a good juncture for me to say that Americans Unite for Life is sponsoring a conference starting tomorrow in McKenna, tomorrow and Friday, entitled the Equal Protection Summit. And one of our panels on Thursday afternoon is addressing congressional power. And Josh and I are also speaking in the morning. But we brought in Professor Christopher Green, Tom Jipping, and James Reed to address that question.
Josh, do you have a question
Yeah.
for Clarke?
So Clarke, do you think that the court got the public meaning of person wrong in Levy versus Louisiana when they said that illegitimate children are not non-persons because they are living human beings, they are alive, live, move, have their being?
Just because the court expands it in one context doesn't mean the court can and should expand it in another. And so the questions that I raised about how the unborn don't fit into the language of the 14th Amendment would have to be considered whether or not the court ruled in Levy versus Louisiana.
Do either of you have other questions for each other? Otherwise, I'll turn to audience
I have another one.
questions.
Unless you
Go ahead.
Okay.
I'm happy to get to the audience here. I have one more. So, in previous back and forths, you've said that the proponents of personhood have to establish by irrefutable evidence this case, and I've argued that it's the best available legal evidence should be the standard. But why shouldn't the burden actually be on your side, Clarke, since the Equal Protection Clause applies to every human being, right? Or at least right now, there's no exclusions from the Equal Protection Clause persons, any category of persons that are currently excluded from the Equal Protection Clause, except the unborn. Why shouldn't the burden be on you to prove that that exception is justified?
Well, I think this goes to the whole question of what does the original public meaning mean? The legitimacy of the Supreme Court of its decisions has to be based on some connection to the sovereign will of the people and the decisions by, for example, the 39th Congress. And there is no legislative history of any kind to show that anyone in the 39th Congress ever considered pregnancy, abortion, or the unborn at any time. And so can the original public meaning include the unborn if the original congressional meaning did not? And there's no evidence to show they ever did. When, for example, Professor Finnis has said that that 14th Amendment personhood would take the issue away from the states. When the states were doing the work between 1821 and 1866 of state by state, law by law, limit by limit, year by year, extending protection for the unborn child, why take it away? Why would the 39th Congress take it away from the state? What you're engaging in is presentism. You're projecting our feelings, our thoughts, our convictions onto the 39th Congress. And that is one of the risks of original public meaning. It can't engage in presentism. It can't project onto the framers or the ratifiers of some amendment how we feel about the issue today.
Can I respond to that?
Sure.
Yeah, so I totally agree. We shouldn't project how we feel about the issue onto history, right? But I think this does put a fine point on maybe where our differences are, because I think that implicit in your critique or your understanding is that the original meaning is determined by the subjective intent of the drafters and ratifiers, which is, I think, an intentionalism that has been rejected basically since Justice Scalia. And so I'm advocating for an original public mean originalism that determines meaning based on what the public would have understood. And maybe original intent is, to the extent that that's relevant evidence, it's evidence of what the public would have understood. And from that, legislative history that we looked at, we saw that it was used in the broadest and most inclusive sense. And so I think that the distinction there between intent and public meaning is really important. And I guess I side with Justice Barrett's view in Rahimi that it's evidence of, subjective intent may be evidence of public meaning, but it is not decisive or determinative of public meaning.
No, I'm not relying on what Bingham thought in his heart of heart, or what Howard thought in his heart of heart, or whether they were personally pro-life. But there is no evidence that anyone in the 39th Congress ever considered the abortion issue, pregnancy, or the unborn. No evidence whatsoever, inside or outside of Congress. There are no editorials. There are no public documents. There are no personal letters, no personal papers that show that the 39th Congress was concerned about the abortion issue. They were concerned about the freedmen. And they didn't have to be concerned about the unborn child because the states were taking care of the issue.
I have a question for you. Could I ask this?
Yeah, and then
We should go. We should go to the audience too. I know.
Okay.
Sorry, I don't. We could go too long.
Sounds good. Yeah, let's get a couple audience questions in. One is from John, and this is probably primarily for Josh. I think Clarke argued pretty convincingly that the holding of Dobbs was that this issue should be decided by Democratic electorate in states. Would you take that ruling of Dobbs to be mistaken and
No.
argue that it should be reversed?
No, but I take issue with calling it the holding. The holding of Dobbs, the question presented to the court was whether pre-viability bans on abortion are unconstitutional. The answer is no. To reach that answer, they didn't have to decide questions about personhood. Yeah, there are lots of asides, practical implications of the ruling not reaching personhood. Of course, the practical implication of the ruling is, yeah, now the states are going to decide. It's going to the states. That's the situation we're in. But that's not the statement of legal principle that decides the question presented. And it wasn't a question presented to the court at all. I know that it was asked at oral argument, but the parties didn't advocate for that position. And these doctrines that shape how we understand and interpret judicial decisions about party presentment and how courts decide cases on the narrowest possible grounds and holding versus dicta is very important. So I take issue with the characterization of it as a holding. I do agree that that is currently the practical implication of Dobbs and where we are now.
May I respond? It's not a question of just two things. It's not holding versus dictum. There is also rationale. And the 6 passages I read are the rationale for sending the abortion issue back to the states. The court said that the Constitution and the rule of law require it. Not just the Constitution, but the rule of law require that we return it to the states. That's rationale. It's not dictum.
So I guess I disagree. It's the rationale, because in my mind, the rationale is actually for treating abortion differently than all the other substantive due process cases is only on the basis that the unborn child is, that this is a human being, right? Because they said that unless, they said it's unlike any other substantive due process case we've decided, right? Those cases like Obergefell, the contraception cases, those cases are all different because abortion is a unique case that takes the life of a human being. And so then the question is, well, if it takes the life of a human being, why is that human being not a person like every other human being?
Okay, a related question from Thomas, who's a 2L, says, given that prohibiting abortion is an area of traditional state function, might some substantive canons of interpretation, i.e. federalism, weigh against construing person so as to deprive states this regulatory authority without a clear textual basis?
Yeah, so I think the answer to that is it's not taking away power from the states. States still have the power to legislate and craft how they want to deal with abortion within a permissible realm, right? The issue is that there's a floor. They can't withdraw protection beyond what was available in 1868 to unborn persons. So withdrawing that protection, that's the floor. But sure, states can decide whether they want to classify abortion as, first-degree murder, second-degree homicide, or feticide. A lot of states have specifically tailored statutes to deal with this. They can determine how they want to deal with, crafting punishments that make sense for abortion providers or crafting immunities for women who seek abortions. None of that is impermissible under the Equal Protection Clause. So this is not taking away policymaking from the states. It's only setting a constitutional floor that if you have a law, a law that says, homicide is murder is homicide with malice aforethought. You can't have a discriminatory exception like unless the victim is Black, or unless the victim is left-handed, or unless the victim is of Croatian ancestry. And that's effectively what abortion regulations are. And that's the impermissible state action, is the legislative act to codify that discriminatory exception.
Any final word in response to that, Clarke?
No, I'm happy to get more questions from the audience.
Okay, well, unfortunately, it is 1:30, so I think we should wrap up the formal discussion. But as Veronica mentioned, we have lunch available outside and encourage you to continue the conversation with the speakers and with each other. And thanks again so much for coming today.
Yeah, thank you.
We should take this on the road. We
It'd
should
be
do more
fun.
Federalist Society.
We should, yeah, that'd be fun. I do a lot of FedSoc events, but usually I debate like they're liberal law professors who don't care about originalism and are pro-life.